So now Sarah's claiming it was self-defense. Whatever she wants to call it, whatever she wants to claim it, we need to get this show on the road. We're going to talk about her latest hearing in today's video. Hello Sofa Squad and welcome back to the sofa. The sofa's back there. Now the new little additions, Bo, William, and Luke Connor, the little puppies, they are actually in the other room sleeping in their little playpen. It has been a very dramatic puppy weekend for them, and they are exhausted. So I started recording, but this is probably going to be a little bit of a longer video, so you'll probably see them appear at a certain time when I hear them start to go a whining and a crying. And speaking of a whining and a crying, we're revisiting the Sarah Boone case today. So if you follow my live chat channel, then you'll know we streamed it and watched it together in real time. I wanted to come over to this channel because I know some people don't, it's kind of two different channels or whatever. Some people don't like that vibe. Totally cool, I get it. But what I wanted to do over here was to go over the actual documents that were posted, just a few of them, and then also some of the highlights of that hearing. Now, here is the thing. Some of these clips we're going to watch, and they're from Law and Crime Network if you want to watch the whole thing without me talking. They're representative of how overall it went. Her attorney, in my opinion, granted, he did a good job as far as, can we throw it at the wall and see if it sticks? Like, let's try every angle. Awesome. He did it. I would want our attorney to do the same, right? Overall, he seemed very unprepared. Now, yes, one side of that is, well, he just came into this late and blah, 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 blah. Well, he knew that, right? So there's that. So I have no doubt that they are working crazy hours, working around the clock. He's getting this person, that person to help, the whole 9 yards, okay? So it is what it is, okay? So just know that really these aren't in any particular order, I should say. And we'll go over kind of an overview in the beginning of what took place and then just go from there. So let's go ahead and get that first document on the screen. Now here you see this is just the order that came through, and it goes down, and we'll just jump down here where it says the court heard several of the defense motions, and there was a lot of them. So overall, what they went over to as it relates is it says motion for statement of particulars denied as stated on record, motions for additional discovery denied as stated on record, motion to appoint forensic psychologist granted as stated on record. The court appointed Dr. Brennan. Motion for cause granted. Motion to appoint crime scene reconstruction investigator granted. Motion for the return of property denied. And motion for enlargement of time granted in part, denied in part, granted as it relates to the filing, objections to the state's evidence, denied as to remaining portions of the motion. Now let's go into that second page, and you'll see here as well, just jumping down there, it says like copies to and whatnot, and payment locations and whatnot. These are just kind of the little particulars of this. So what we're going to do now is we're going to go ahead and just get into some of those clips, as well as, like I said, we'll be sprinkling some of the documents in to go over it. So let's look at the first clip here and just jump on in.
And the request was for the written policies and procedures of the Orange County Sheriff's Office relating to the in-house interrogation procedures, in particular the policies and procedures in place in February of 2020, and the written policies number 2 and procedures of the Orange County Sheriff's regarding Miranda rights, written policy, the form and the card relating to Miranda rights utilized and read directly to the suspect before any interrogation in effect in February 2020.
I mean, can we say policies, procedures, and Miranda rights anymore in that little clip right there? Now, what he is talking about is the infamous interview, right? So he is talking about the infamous interview with the police that she sat down with or whatever. This was a huge point of contention. And so I just wanted to put that there so you can kind of hear his main thing that he's going on about, which was like, what's the policy with the Miranda rights? He's basically trying to get this suppressed, okay? Like that whole interview. Again, I would want him to do it if I was in Sarah's place, okay? I 100% get that, right? So he's trying to get it suppressed any which way. He's going to the Miranda rights. One thing I want you to pay attention to as we look at some of these clips, and again, if you watched it live chat or whatever, then you already know, the judge and how much prepared the judge is. Now, granted, the judge has been on the case for 5 years, right? So I get that, but how just quick he is with receipts and case law and this and that and blah, 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 blah. So my hat's off to him. Let's get to that next clip.
So as you know, Judge, I don't know if you've actually watched the 2-hour interrogation, but the day after this event, she was asked to come down to the Orange County Sheriff's Office under what my client believed was something other than an interrogation. When she got there, she was directed into a room, and I don't know, like you said, you haven't had a chance, but there are some serious issues about whether or not that was coerced, whether or not Miranda rights were fully read. I do not believe they were.
Okay, so a couple of things right here. The reason I pulled this clip out. Number one, when the judge was like, I have not seen the interview. I was like, now I get why, okay? But I was just like, this man has been denied pure. I hate seeing comedy gold because it's not comedy, right? Because of the center of this is George and his loss of life, okay? The comedy gold part of it is watching someone who proved over time, yeah, they're not going to take any level of accountability. Even once she's gotten in and sobered up, we're seeing the essence of who she is, right? She just doesn't seem like a very good person is what I'm trying to say. And so you're watching them get caught up in this, okay? And so for the judge, having dealt with her for 5 years, when he sees this in trial, I want a camera on his face. I want to see this man's face in real time as this plays. In the live chat, I was talking to people and I was like, you know, him and his wife watch this nightly, right? Nightly. And they'd be like, hold on, dear, be quiet. This is my favorite part coming up. You know what I'm saying? So yeah, when he said I haven't seen it, I'm like, my God, give this man something.
Where she could not leave with 2 homicide detectives. One was wearing a firearm, and she acquiesced to authority based on an improper reading of Miranda.
Okay, a couple of things here. Now, again, I didn't say in the beginning, I always forget, but just so you know, if you're brand new here, I'm not a doctor, I'm not a lawyer, I'm not a therapist, I'm not a cop, I'm not a PI, none of that fancy stuff. Only credentials we got up in here is that damn sofa, some sass, and some personality disorders, okay? Well, let's be real honest about that one, okay? I'm talking about myself, okay? So just know that I am not anyone to sit here and properly diagnose someone or anything like that. These are just opinions and thoughts as we go, okay? So when he's sitting here talking about the Miranda rights thing, and again, I get where he's trying to go, where he's trying to, get that. So if you've watched the interview, when she goes in there, first of all, she had a list of questions, right? And I said this in live chat, I was like, they could barely get a damn word in. Okay, they could barely get a damn word in with Sarah. She had a list. She slapped that person down. She wanted management, okay? So it's funny that he's like, well, they had a firearm, and I'm just like, again, from the legal game thing that's going on here, I get it. More power to you, buddy. But yeah, she wasn't coerced in this, okay? I know she's trying to say that now. I get why. But evidence will show she was ready to talk, and talk she did.
Your Honor, it's not Mr. Owens who's on trial, it's Sarah Boone. Sarah Boone was interviewed by the Orange County Sheriff's Office on February 24th and 25th of 2020. Now, some 4 years and 7 months later, there's this exigency not created by us, created by them.
Okay, state prosecutor, state attorney, whatever. Excellent point here. It's not the new attorney who's on trial, it's Sarah Boone. She's had all this time. It's some of the stuff that the attorney will come up with, it falls a little bit on deaf ears because of just what all has gone on beforehand. Now, obviously, there's the legality part of it, and it gets very cumbersome because, I go back and forth where I'm like, ugh, like, what do you do in this scenario, right? The judge was exhausted with everything, did all he could. Look, I'm going to make you go pro se. You have... you've spent all your chips here. You know what I mean? We're not going to play your game anymore. No more attorney for you. You have to represent yourself. Then this guy steps in. Okay, here we go. But it's not going to change, the timeline. So that's the part when her attorney comes up and, tries to make that argument that it's like, it's not going to fly here. I don't know if the judge in this case is at this point, like, just get it on appeal. This is getting out of my courtroom, though. I'm done with it. I'm finished with it. What do you do in this scenario? These defendants, such as Sarah, Daryl Brooks, people like this, where they know how to drag the case out for years and years and years. It's just, I mean, where do you go at a certain point?
What they do have and what the defendant has had since February or April or whenever discovery went out in 2020 was a videotape of these interviews. There has been absolutely nothing stopping anybody from filing a motion to suppress if they believed under the case law relief could be granted under the law. and the law does not have any analysis regarding standardized issued Miranda cards or policies of law enforcement agencies.
So here's the thing, where her attorney's like, I want to know the policy for Miranda and how it's supposed to be in the cards and blah, 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 blah. And the state attorney's bringing up a good point where he's like, they've had years to do this. So now all of a sudden you want to suppress this. Now all of a sudden you want to bring this up. A lot of this lies in what the issue was with all her previous attorneys as to why it could never get to that point. If that was one of her arguments that she wanted people to do, and maybe that's what we're seeing, where she's saying, no, I want you to go up here and argue, the Miranda rights. And maybe the other attorneys were like, that's not, I've seen the evidence, it's not going to fly. And maybe this guy is just literally just being like, Sarah, give me your list of all the things you want me to say. And he's just checking them off, right? I don't know. I don't have that perspective of, oh, I know what the law is and I know specifically what it is and for Florida and whatnot. And like with this particular case right here, or situation, I should say, but again, from a SOFA perspective, I can understand where the state attorney is coming from in that we've had years to do this. All this. Why are we now bringing this up other than stalling or just causing drama and whatnot?
So where's the violation of the Constitution then? Assuming you're correct and assuming that the Miranda card, something was missing, what's the issue?
It's coercive. The statements that the lead detective, the female detective makes, there's 2 or 3 statements she makes.
Now you have to understand, I'm in a vacuum here because I haven't watched the video. I'm not asking you to play it.
I probably should have.
But I need a little bit more context as to these statements because I have unfortunately no frame of reference.
But she says they.
Okay. This is like the beginning of the back and forth that goes on between the judge and him. Now, again, you heard the judge sit here and say, I've not seen the video. I need more context. I need this. And I will give it to the attorney. Some of the stuff that he's bringing up, I'm like, okay, I get what he's saying, right? If there was some form of a discrepancy with Miranda and all that, of course you're going to want to try and see if you can get thrown out. Anybody would, right? I mean, who wouldn't, okay? Because here's the thing too, as much as like some of these situations like this where, and again, I'm thinking these defendants, most of the ones that we cover here, who it's pretty obvious, what took place. They've done something pretty atrocious that has resulted in someone losing their life in most usually a heinous type way. And so it's easy to get frustrated with them or to lack a little bit of empathy versus maybe some other kind of situation or defendant or whatever, right? So regardless of all that, the fact of the matter is, removing emotion from it, yeah, if there was Miranda rights and the cops messed up or they violated something, it is what it is. You have to cover it. You have to go with that, And this is not to say that cops are not cops are human, okay? Like in these moments and whatnot, you can mess up, you can do that. But in this particular situation, okay? Let's reel it back into that. I don't think that's the case personally. And you'll hear throughout the judge, it's almost like Sarah's attorney. And in live chat, I was like, I think he's working for the state. Some of the stuff he does, the judge will be like, yeah, exactly. And like it's almost like he's not painting her picture out well. And we're getting ready to get into some of that. So just buckle your seatbelts up is what I'm trying to say.
I got to read you these Miranda rights again. And
Again,
she had read them. There was a statement that Sarah Boone gave. Of course, she gave a general statement to the first deputy that responded to the scene. She was wearing a body cam, so that deputy had called the 2 homicide detectives, but it took them a while to get there. So she asked Sarah Boone what had happened, and Sarah explained that situation. After the detectives got there, they took a general statement from Sarah, but at some point they got into one of the squad cars. And I believe it was Sarah Boone. I believe it was the female detective and the male detective. And she was read Miranda rights, again, incorrectly, and she gave a statement.
Keyword, again. Now, essentially, what Sarah's defense attorney is saying is that, she was kind of brought down there on false pretenses. I don't know if I took the clips out here, but I might have, where basically they had told her, oh, you know what, I don't feel like returning your phone, come down here and get it. And it was, oh no, the phone's back here, come get it. So they're kind of manipulating her to the back. Now, we've seen what the cops saw, right? So when they saw that, they probably at that point were like, look, we're getting an arrest out of this. We're just trying to extract a confession or information or whatever, okay? Now, again, this is not to say that cops won't, fudge this or fudge that or whatever. I get that, okay? But you saw in this at the beginning where he says, again, and the judge went, again. So the judge is like correcting him, and it's almost like, dude, you're not making this any better for Sarah's case, okay? Again, A for effort, but it's like they've read her these things multiple times in different situations, but he's saying incorrectly, okay, nice try, right?
That you've got to get the waiver. There's two questions at the end, which is, did you understand the rights that I've just read to you? And the next question, understanding these rights, do you agree to speak with us now? That question was not read. It was omitted. I don't know why. She's sitting there reading it, and
Does the fact that that question was not read impact constitutionally under case law the admissibility of those statements?
I believe so, along
That doesn't
with
answer
her
my
other two
question.
statements.
Respectfully, that doesn't answer my question. I understand what your belief is, but where's the case law that you can provide to the court?
I'm not ready for that, Judge.
Okay.
I'm going to file a motion to suppress, and I'll supply you with the case law, but I'm not ready for that. But the reason I wanted the policy, getting back to your first question.
Okay, so here, this is one of the dynamics of true crime that fascinates me, and that is the legal dynamic to it. So you hear what he's saying, the judge, who's like, look, how does this violate this? By not reading our last question, the constitutional law, do you feel it does? I feel it does. That doesn't answer my question. Where's the case law? Where's this? Well, I'm not ready for it. This is what I'm talking about. This is what happens when you swoop in at the last minute. And again, it is what it is. His client has created this scenario, and he is coming at the last minute and trying to fight every little last thing. You can only put so much time and energy into something, right? So again, this is one of those just trying to throw everything at the wall and see what sticks, in my opinion. You heard him at the very end, I'm going to file the suppress thing or whatever. So, maybe by the time you see this video, they would have already come back with another hearing. So, but this kind of dynamic, this back and forth, this gets even more heated as this whole, I think it was like a 2-hour hearing, goes on, because this is just the general vibe of it, right? This attorney is not that prepared for it. He's kind of going back and forth. He's picking little things apart. And the judge is like calling him out on it. Where's the case law? I don't have it. Okay. Where do we go with this? Because right here you heard him say, well, she didn't read that last question. If you watch the video, again, if the judge had watched the video, and again, I don't think he can, so I'm not faulting him for that. But in my opinion, again, non-legal perspective or non-legal background, whatever you call it, she knew what she was getting into. Because remember throughout the interview, and we've watched it so many times here at both channels, but we'll do it again. So if you remember during the interview, she expresses concern. Like she's getting a vibe of like, am I going home? Like what's going on? I have this, and she'll do little things to test throughout, right? Now again, if they messed up and they got an improper confession or information, then absolutely, right? I mean, that's, why the system is the way it is, dot your I's, cross your T's type thing. So let's keep going.
Relating to
Don't
costs.
know that I have. I'm just going by what the notice of hearing reflected. So no, I don't.
I filed a second amended notice of hearing. I don't know if you got that.
Was it forwarded to my office? Because if it wasn't, I don't know.
I'll
that I
have to
got it
ask
yet.
Margaret. I don't know.
Okay.
But I filed a second amended notice of hearing. Can I
Please.
give you my copy?
And Mr. J, have you seen that, sir?
State doesn't really have a dog in the fight with the expert appointments.
Understood. Thank you.
Judge, what I had done
Don't
was
see
I
a date
had,
on here, Counselor. When was this sent? The certificate of services contains no date.
it was filed this afternoon,
Okay.
this morning.
Okay.
Like so embarrassing, right? Again, when he's like, there's no data on, there's no this. I mean, you just get this vibe. I mean, you see, and again, I've said it 100 times. I'll say it 100 times throughout the case, the video, whatever. This is, you're watching someone swoop in at the last minute and take up a case for whatever reason. And like Vinny from Court TV says, everyone deserves a lawyer in situations like this. You kind of expect somebody to come in and help the defendant, right? Because, I mean, here's the thing. And yes, put everything aside. Put the fact that, again, at the center of this is a victim, is George. From there, put out, the legal system, that whatever. Would it have been entertaining to see Sarah represent herself? 100%, right? I get that, okay? But it would take forever number one. Number two, I just really think she would use the opportunity to victimize other people, like his family. Who knows, right? And especially what we learned from this hearing, like some of the witnesses are going to get up there, her ex, people like that. I mean, I'm just like, oh, thank God somebody came and took this up, because this would be a you-know-what show.
With regard to the motion to appoint clinical psychologist, when was this motion filed? Similarly, the certificate of service does not reflect a date.
Let us check real quick.
Sure.
Give me a minute.
Yeah, you're good.
Again, I just, added that in just to kind of show, if you haven't watched this or whatever, this is just what was going on, right? Now, again, remember, so today is the 22nd and it's Sunday, so the 21st, 20th. What was this, the 20th, I believe, that this took place? I can't remember, the 19th, something like that. Regardless, what I'm getting at is October 7th is trial, okay? So they're just getting into all this type of stuff. Now, on that note, let's take a look at some of the documents that came through to just get through some of these motions, what took place, what they were about, the whole 9 yards. So let's put the first one up on the screen now. Okay, now on the top of this one, you're going to see order on defendant's amended motion to appoint forensic psychologist. And let's just jump down there to number one. It says the defendant's amended motion to appoint forensic psychologist expert is hereby granted. Julie Harper, PsyD, is appointed as forensic psychologist expert to assist the defense. Now, we already did this in other videos and went over her and whatnot. It says that Dr. Harper is authorized at a rate of $200 per hour for work and travel time with an initial cap of $7,500, exclusive of necessary cost allowed by statute. In addition, reasonable coverage for travel and travel-related expenses capped at $2,500. Okay, so pause right there for a second. So basically $10,000, right? So I'm like, can you imagine? That's a lot of money for... Think about how long. I mean, granted, she's going to have to interview whatever. She's already done stuff. I get it. But, I mean, that's the kind of money these people are raking in, right? Okay, let's keep going. So, number four, that the Justice Administrative Commission, so the JAC as we hear them talk about them, for the state of Florida is responsible for all costs related to appointed expert and travel expenses to Dr. Harper. The defendant is liable to pay the amount of any due process costs provided to defense as directed by section. It lists them off, Florida statutes. If the defendant is convicted, the court is responsible for determining the amount of the obligation to be imposed as a lien against the defendant. Well, my goodness gracious. They're going to put a lien on this damn honey bun. Can you imagine? Okay. Take out, like, guilty, whatever, like, right, wrong, indifferent, whatever. You get convicted, you can't pay, and they put, like, a lien against your honey bun fund or your commissary or whatever it's called. Like, do you know how bad that would suck? Okay, like completely, that would totally suck. So if they're like, look, you're gonna have to break off some of the honey buns, Dr. Harper, those soups, go on, send her half those ramen soups. You ain't getting all that either, right? So there's that motion or whatever. Let's go on to the next one. Okay, the next one here at the top, you'll see it says order on defendant's motion to appoint clinical psychologist. Let's just jump down to number one. It says the defendant's motion to appoint clinical psychologist expert is hereby granted. Number two just says Dr. Brannon is appointed as the clinical psychologist. And then going on down to the third one, it says that he's been authorized, or he or she has been authorized at $160 per hour for out-of-court services and $170 per hour for in-court testimony. Cap of $7,500, exclusive of necessary cost allowed by the statute. And again, they're offering him $2,500. And it goes down to say the JAC is responsible for all costs related. And then it goes on down there to say the same thing about putting the lien against those honey buns and the soups and whatnot. So again, we're looking at 10 grand here. So this is another thing that's interesting is when you see how expensive these trials are. And I'm not saying like, oh, whatever. Yes, I get in this particular one, it's a little bit like seriously, but you can't view it that way, right? Because it's like you can't pick and choose who gets what in the justice system, okay? Even though it kind of does. You know what I'm saying, though. But nonetheless, I mean, this is just these two people for just the defense. The state has unlimited. We're just going to throw whatever we want to at it. So this is where this gets, how much money this case right here, this trial, has cost the taxpayers probably an insane amount of money, okay? Let's keep going. Let's go to that third one. Now, the third one you're going to see at the top where it just says the defendant submitted a motion to appoint crime scene reconstructionist and death investigator. And let's just jump on down to number 1. It does say that that was granted. And then number 2, it says Dr. Birkeland is appointed as a crime scene reconstructionist and death investigator to assist the defense. And again, it says they're authorizing $200 per hour for 50 hours of work with an initial cap of $10,000, exclusive of the necessary costs and whatnot. And again, it says those things are capped at $2,500. Same thing for number 4. The JAC is responsible for the cost, and then going on down to that whole lien against the honey buns and the ramen noodles. So 10 grand, what was it? 10 to 10, $30,000. You please. You know they're capping out, okay? They already did with the one dude, her, what is it, the private investigator or whatever, Florida, I can't think of it right now, but the investigator that's been on her case, and Prison Break, he's already like up the ante or whatever. So I mean, that's just this right here. I would love to know a figure when this is done with how much this case / trial cost. Okay, so now let's go back to the courtroom. Let's look at again some more footage of her attorney up here arguing, and let's go on to the next thing and see what they got to say now.
So we would submit that the property should not be, based on the authority the state attorney has cited, the property should not be returned to the defendant since trial is still pending. But in the alternative, we're asking for an independent exam by the defense.
Response, if any?
Okay, I'm going to give you 3 seconds to guess what they're talking about. A 1, a 2, a 3. We're talking about that cell phone. Very fixated on the cell phone we are. Again, there has to be a love-hate relationship with it at this point, right? I mean, come on, it's like really why she's here. Meaning, videotaping the actions that she did and forgetting they were on there. Obviously, she's the reason she's there. Let's listen to what the state has to say, because when this came up, I was like, why are we still on the cell phone? Why are we still? But again, this is where my theory is this. I'm curious to hear what other, real attorney, listen to me, what other attorneys, you know what I'm saying? What people who actually have degrees in this have to say. My theory is that this dude's up here with a list of stuff from Sarah, right? It's just a list of stuff, like going down it. Now, obviously, there's going to be stuff that an attorney would go through to be like, well, let's try ABC. But I just feel like this guy has a list of stuff that Sarah's come up with that it's like, I want you to say this and do that. Let's see what the state has to say now.
Has the defense ever performed an evaluation of the phone? And the reason I ask this is there were prior experts that were appointed in the realm of electronic evidence.
Mr. Cacciatore may have the answer to that question. I don't, but I know that the state, as I stated in my response, we've never prevented anybody from doing that. And as the homicide supervisor, everybody in the unit knows how to go about doing this and allowing a digital forensics examiner hired by a defendant to go and work with the law enforcement.
I mean, super cringe, right? Again, this is where it's just cringy. I mean, there's nothing else to say. You know, I don't disagree that it's good she's being represented. These are great things to bring up. But just like this other stuff, and when I say other stuff, specifically what I mean is like the discovery. Think of all the hearings we did for her to get access to the discovery when she was doing pro se and all that type of stuff. And then coming in there like, oh, I haven't looked at it. I haven't looked at this. I haven't looked at that. This is the same thing. It's been how many years? You've already visited this to have this examined, and it was never done. So why is it important now? You know, because she could never, in my opinion, she could never lift off to get to that point with an attorney. She probably was saying, no, I want to be able to have access to it, or whatever the case was. Or, you know, I want you to look at it, whatever. And so she would thwart the system, and they could never really get to this point. And that's where it's like, look, you can't have it both ways. Let's keep going.
And of course, I had just gotten discovery. Judge Creighton, we have not finished reviewing all the discovery in this case. I pretty much shut my law practice down to try to do it. I've gotten my staff, and we're trying diligently to go through all the discovery.
I mean, on this one, I'm sorry, but we got to drink it from the damn cup on that one. Mr. Owen, right there, drink from the cup on that. Okay. It is what it is. This is what I'm talking about. This is going to fall on deaf ears. Because you know this judge is sitting here like, yeah, you kind of knew what you were getting into. Okay, now let's get into the heart of this video, okay? And that is going to be what they are saying is going on now. Now remember, battered spouse syndrome, this was thrown around, that was thrown around, blah, blah, blah. This went on and on in this hearing, okay? So what I want to do before we get into some of the highlights of that, because there are going to be long clips that we put up here, I want to read one of the motions, okay? So, because this was so cumbersome, I was just like, I can't imagine. You'll see the judge at one point where he's like this. I think I have the clip where he's like, is there anything else? You know that he's like, my right eye is involuntarily twitching with a direct acute pain behind it. Okay, because I feel that way and I'm not even there or personally invested, more than I am already. Let's get that first document on the screen. Okay, so here at the top, you'll see where it says, state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome. So let's just go through these. So number one, the defendant filed an amended notice of intent to rely on the defense of battered spouse syndrome, September 15th, 2024. So yesterday, right? Okay, the defendant was provided discovery over 4 years ago. The defendant's own admission, her expert Dr. Julie Harper saw her in 2020. The discovery in this case shows that the descendant and the defendant engage in alcohol-infused spats of violence against one another periodically. We'll hear from him in a moment talking about this, and I'm pretty sure I have the clip there, but very interesting points that he brings up. So, number 5, this no more describes the criteria for battered spouse syndrome than a mental illness describes insanity under the McNaughton rule. Number 6, the conclusory statement that in particular the evidence will demonstrate factors that trigger BWS, the physical symptoms experienced during BWS, the distinct behavioral and psychological symptoms exhibited by the defendant that are consistent with a person who suffers BWS, and the impact of BWS as it relates to the facts of this case does not set forth the particular evidence that shows the defendant suffered from this syndrome. Okay, so a lot of stuff there. Let's go on to page number 2 of it. Okay, so number 7, the state's concern that what the defendant is alleging does not meet the criteria for BWS is not premature. The discovery does not support a diagnosis of BWS, and the defendant has not alleged new facts to support BWS. This is going to be at the center of this. BWS is not actually a defense to a crime. Now let's go through this right here because I find this very interesting. The introduction of battered spouse syndrome evidence to support a self-defense theory is not for the purpose of justifying a defendant's misperception of reality or to explain why an unreasonable belief was nonetheless justifiable due to her condition. Rather, the Florida Supreme Court has sanctioned the use of battered spouse syndrome to show why the defendant's actions were reasonable, to show in spite of a reasonable perception of danger from the battering spouse. The battered defendant would remain in the home with her batterer where she may resort to the exertion of force against him to prevent imminent death or great bodily harm. Now that goes on to list, case law and whatnot. So let's jump on down to number 9. It says there's no evidence of justifiable use of deadly force in this case. The defendant has not alleged any such new evidence in her notice of her intent to rely on battered spouse syndrome evidence. Number 10. What the defendant told law enforcement was, now this is major here, okay? And this is one reason why I wonder if this is what was going on with her other lawyers, because if they were telling her, you can't, it's not going to work. But she's like, no, do it. So let's read through it. When asked about the descendant's other injuries, in all honesty, we have not gotten into it. She said that the whole time. We're talking about that interview, what she told the cops, right? B, the defendant said that she and the descendant were having a good time on Sunday, having wine, painting, doing puzzles, and listening to music. Nobody laid a hand on nobody. C, I have not touched him. We had a good day. You know he was going to throw that in. You know he was going to throw that in there. It was a good day. We've had good days lately. Again, this is all what she's saying, right? She convinced them of this, that it was a good day. Let's keep going. There was no ill will between us last night. That last argument was maybe last week. I was so happy, like it was such a good day, I kid you not. Nobody touched nobody. Nobody touched nobody. It's the drinking. That's what it is. It's the drinking. I thought he was okay. Everything was fine and dandy. Question, why didn't you just let him out? Answer, to be honest with you, I don't know. K, I will never drink alcohol again. I, question, what was your motivation for leaving him in the bag? Answer, I didn't have any motivation. It was me. He and I having a great day, fooling around and being stupid, and apparently me going upstairs and going, I'm guessing, I'm blaming it on the wine. can't roll my damn eyes hard enough at that. How about we blame it on Boone? Okay, how about that? Okay, M. Question, you two didn't lay hands on each other? Answer, no. N. I don't have any injuries. He and I have not been at it with one another. O. She didn't do this intentionally. Alcohol is a essy, you know what thing. P. So it's like, okay, so while we're in a good place right now, I'm gonna snap. Is that what it, while we're in a good place right now, let's keep going. Q. See, that's the thing too. You can clearly tell that I have been drinking some. R. I didn't touch him, nor did he touch me. 11. Let's just jump down here. The defendant's account is not one of self-defense, but rather an accident. Wagner versus State. Now, this will come up as this is argued and whatnot through in this hearing or whatever we watched. Continuing on, it says, as the defendant has changed her account, she has not alleged such in her amended notice of intent to rely on the battered spouse syndrome. 12. Therefore, the State renews its request for the court to strike the defendant's amended notice of intent to rely on the defense of battered spouse syndrome. It does not set forth with particularity the evidence that would show the defendant meets the criteria. Additionally, State renews its request to prevent any mention of battered spouse syndrome until admissible evidence of a justifiable use of deadly force is admitted into evidence at trial, and admissible evidence of battered spouse syndrome is admitted into evidence at trial. Just goes on to some stuff there, like case law and whatnot. Thus far, the State is aware of no evidence supporting the defendant suffering from the syndrome, only evidence of alcohol-induced violence between both the descendant and defendant. There is zero evidence that this was justifiable use of deadly force. The defendant has stated the exact opposite, and she is the only one who can testify that it was justifiable use of deadly force. So there you go. Okay, this is huge, and I'm sure that her attorneys told her this along the way of, what are you talking about? What are you talking about? Well, we're going to see how jumbled and caught off guard her current attorney gets with this. So now let's get into some of that testimony that took place, or testimony, just some of the going-ons in the courtroom. Let's go back to the courtroom is what I'm trying to spit out.
The State is not surprised by any of the evidence that has been in the discovery for years. I'm not going to belabor the facts in the discovery, but suffice it to say that the decedent and the defendant had a violent relationship, and generally this violence seems to be fueled by alcohol. We're completely aware of all of this domestic violence history, but that does not make a battered spouse syndrome defense any more than being mentally ill without showing more makes for an insanity defense. Their original notice was insufficient, and there's no reason to argue it since they've amended it. So turning to the amended notice, it still does not set forth what they are going to show that shows that she suffered from battered spouse syndrome.
Thank you. Right? It's so nice to hear somebody say this. And this is the kind of stuff that we're going to hear during trial. And this is where you're listening to it, and it's just like, why didn't she take a plea deal? I don't know what the plea deals were. I've heard 10 years, but I heard that was an internet rumor, so I don't know if that's confirmed or not. But you're going to hear this evidence. You heard them list out all the things in the interview, so of course this shows you even more why they would want to get it suppressed, right? Again, anybody would. No one is denying at this point that, like he said, this was a very toxic relationship on both their parts, okay? No one's trying to say it wasn't. And what the state attorney's sitting here saying is like, look, this is, we get that. We know that. That doesn't change anything. She showed no signs of this syndrome. She went on and on and on and on and on about it. Even per her words, nothing was going on. At this point, she knows the man's dead, right? So in that case, if you were going to sit here and try and get yourself out of trouble, he's dead. Like, he's not going to be able to hurt you again. Why wouldn't you be like, yes, you know what? Oh my God, it was horrible. It was horrible. Because someone truly suffering at this, I can understand why they would lie. Especially if the abuser is still alive, right? Because it's like, oh, he's going to come back and this would be when he takes me out. So I'm just like, I got to say what I got to say. I can't make it worse. He'll just get right back out of jail. She knows George was dead. The truth was I think the truth was just that, what she said, blame it on the wine. I think that's the center of it. I think that's what her and George did. I think that they were toxic to each other, and this got way out of control. And alcohol was at the center of all of this.
Was the decedent isolating her from her family and friends? Was he telling her that if she ever leaves him, he'll kill her. We have these instances of violence between the two of them. And when we get referred to the ex-husband, Brian Boone's deposition and statement, what he reports is that Sarah Boone would attack him, scratch him, punch him, and that she was a habitual alcoholic.
Y'all, that's not funny. But again, this is what is going to be on the stand, okay? I am sure that her previous attorneys told her this, okay? He's going to get up there and talk about just putting her laundry out there. I can almost without doubt tell you the way that things probably went down in that household is she would get set off very easily over anything. If you've watched all the different footage of her during all these different body cam arrests and stuff like that, I don't even know if she's aware of what she's saying or doing in most of them. So imagine the moments leading up to those where police are being called and brought in and that kind of stuff. I mean, there's no telling the direction this goes in. And as we'll hear, I don't know if I have the clips, but I'll say it in case we don't. I mean, neighbors are going to be testifying. It's not going to be a cute look. If she is convinced that she can talk her way out of this, that is a whole new level for me.
And he would have to lay hands on her to restrain her. So we are going to potentially dive into all of this information in trial, but there are still the rules of evidence. And the cornerstone for the battered spouse syndrome defense, which is a misnomer under the case law because self-defense is defense, and battered spouse syndrome evidence is relevant to help a jury understand why it's objectively reasonable for a battered spouse to stay in a situation that puts them in fear of continued violence.
So like he's saying here, and going deeper into this, there's just no evidence for it, okay? There's going to be all this evidence coming from Brian. All the things are going to be there, right? And so this is the part that I guess I'm just psychologically fascinated with Sarah on, because I'm like, what? I don't get how she's going to get out of it. Now, in a minute, we're going to hear him talk about a narrative, a testimony, this kind of thing. If you watch the Robert Tellis trial, you know what I'm talking about. And I really think at the heart of this, hearing all the things we're hearing now and about to hear from the state attorney or whatever, like with the things that are going to come out in the stand, I just feel like she's convinced when she gets on that stand and tells her side that the jury will believe her. And it's not going to end well.
The state and wherein our confusion lies is nowhere in any of the witnesses or any of the discovery that they have listed, exhibits that they don't even have been listed, medical records and so on and so forth. Nowhere does it set forth this cornerstone that is absolutely necessary before we get into any of this battered spouse syndrome evidence.
I mean, that's the part that's confusing, right? And obviously, this is just the state talking. So I'm kind of looking from the judge's perspective of, okay, well, the state's saying this, nothing is being presented in that way. Again, to me, my opinion, this is all coming from Sarah. She's had all these years to sit here and cook this up with zero, and I mean zero understanding of the law. Now, she's not trying to say that she does. And again, you can sit here and be like, I don't know the law, but at the same time, two things are true, right? She's trying to badger her lawyers while at the same time not knowing anything about law, okay? So it's almost like, which one do you want, Sarah? Clearly, this is going to fizzle. And I think herein lies, too, if you read between the lines, with, some of the things the former attorneys have said, in addition to, being yelled at, called names, all this type of stuff, like these morally ethical things or whatever, I just think that Sarah's basically asking them to create something out of thin air. And it's like, we can't do that right now. I don't know, legal wise what that means, but if you have, a license, a law license with a bar and whatnot, you don't want to jeopardize that over a client, right? That's number one, whether Sarah's lying or not will come out in the stand, or the trial. But number two, that's calling you names and doing the stuff that we've seen her do with her attorneys, right? It's like, girl, I'm not losing my license for you.
Before we get into any potential reputation for violence evidence of the victim, before we get into any potential specific acts of violence by the victim, before we get into the rebuttal evidence that is going to be offered against her for her violent nature and her drinking.
I mean, he's just laying those damn receipts down on the table, okay? I can't wait, y'all. I cannot wait till opening statements, okay? Because again, he's just sitting here laying this out. You know she was over there punching air. You know she was over there punching air. They needed that little shock belt on her. Okay? You know they were firing it up if they had it on her right there. Like, she might be working up to a little 1 or 2 zap over here, okay, over this one.
The cornerstone is self-defense. Her statement to the police is not one of self-defense. It is one of accident. She repeatedly says there was no violence that day.
Again, absolutely. I 100% agree. You know, there's, and I see this in all the videos or whatever, so there's 2 versions of this. Do I think that, like, she started out that day with, I'm going to put him in a suitcase and I'm going to take his life? No. However, I do think once she was inebriated, they were doing their thing, arguing, and he was asking to be let out, and she said no, you get into the intentional aspect of it, even though she said unintentional 100 times. It's like, but he said he couldn't breathe, right? To me, that almost qualifies as, like, first degree. So it is what it is at second degree right now, but you see where I'm going with this, okay? That's the dynamic that I just, you know, there was clearly a breakdown in the interview where she kept trying to reiterate to the cops, and in her world, the way I interpreted it was because she's thinking, I didn't mean to do it, therefore I shouldn't get in trouble for it. And again, to me, I'm like, yeah, I don't think you intentionally started off trying to take his life, but I think you were being cruel. And when someone's sitting there saying, I can't breathe, help me out, and you go upstairs and pass out, and I could see her being like, thinking this in that state, I'm gonna go upstairs and paint a picture and let him stew on it and then come back down. And she wakes up 15 hours later, and that's probably something that happened. So in her world, she was like, oh my God, you know, and then of course, oh my God, he's dead, right? So I think something of that nature is probably what took place, but that's not clicking with her, and it hasn't. She's never taken any level of accountability. However, I understand she's fighting the case. She's not going to sit here and do that, because essentially then it's like, well, that's going to be used against you, right? She wants her best outcome. Anybody would, all right? Let's keep going.
And so that's in part why we filed our motion in limine with that response is the court can and should not allow any mention of battered spouse syndrome come in until self-defense has been established at trial. And as far as I can tell, the only person that can set forth a self-defense claim, since it was just her and the decedent in the apartment that night, is her. So she'll need to testify, and then she'll be impeached unless there's a ruling that the statements that she made to the Orange County Sheriff's Office are not only a violation of Miranda, but are involuntary and unavailable for impeachment use.
And this is a major thing right here, and this is what we're going to see with this. If she gets up there and starts saying this and doing that and I mean, you heard the state attorney, they're like, look, we're going to impeach you. You know, and I 100% see this going in that direction. Because she squirms around everything, when she gets on that stand, if she gets on the stand and they start questioning her, it's going to fall apart very quickly, because she's going to have to lie to support this new defense. It's like, why were you lying so much? So if she could get that thrown out, it would only behoove her to, right? Let's keep going.
From the trial court in Wagner, and has looked at the notices that were filed in that case for the battered spouse defense.
Judge, ultimately, the female defendant in that case claimed that the firearm discharged accidentally.
Correct.
And the court ruled, hey, you can't have it both ways. It can't be an accident and at the same time be intentional that you committed as self-defense because you're a battered spouse.
Right.
Okay, this is where I'm talking about, where I'm like, he has to be working for the state. And you heard the judge, right. Like, we've been trying to tell you that, okay? You just laid out so much. Like, if you watch anything of this hearing, go towards the end of it to this section, and watch the whole thing, because it is fascinating how much in my opinion, he puts things out there that it's like, it does not sound good. So that's where I'm like, is this all for Sarah? That he's trying to argue what the client wants. I'm going to get up here and argue what you want the best that I can. And you see where that kind of falls apart, because it's like, yeah, you can't, we've been telling you this. So why aren't we getting it? I mean, they go back and forth for a while over this, okay? Let's get to the next clip.
Self-defense.
But every case that you cite, Medina, Hickman, its progeny, all pertain to some act by the accused. And that battered spouse is an excuse, a justification, an explanation for those actions. How is your purported defense applicable legally?
That's the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that she did, what overt act or what omission. The overt act, was it zipping him into the suitcase?
But
Was that the overt act that caused the death?
But all of the battered spouse syndrome cases talk about a defensive issue. Not meaning defense, your side of the ledger issue. I mean an action in defense.
Okay, I want to pause there real quick, because I'm not going to lie, I'll forget what I want to say. Okay, we're at that point in life. Okay, so you heard him say, that's why I wanted the statement of particulars. They go over this and over this and over this. And again, I don't know if I put the clip in there, but the judge is basically like, there's nothing on there. Like, the judge is almost baffled why he keeps asking for this, right? Because he's like, what? I don't know why. Nothing's going to change that you're asking for. Okay, so keep this in mind as we go to the next things here. All the stuff that he's saying, because this is where the judge is heated, right? He's like, all these things here require A, B, and C. It's not like, where is the disconnect? And he keeps trying to blame this. Now you'll see the outcome in a minute, which is where we get to like the title of the video, like, oh, we're changing the defense up now, right? It's like, oh, it's this, and it's such a shocker, because you're like, what? How? But we'll talk about when we get to it. Let's get to the rest of that clip.
Wagner fired the gun. It was accidental. Hickman fired a gun. There was an act that was done by the victim or by the defendant in those cases. And battered spouse was used as an explanation for why it is that they did. How is that applicable to the case at bar?
I assume they're going to say she overtly zipped him up in the suitcase. I assume they're going to say he was asking to be let out of the suitcase, and she refused. She failed in a duty to act. Later on, she went upstairs and fell asleep. So it's either an act or an omission, but they're claiming an act or a series of acts led to the death of Mr. Torres, which they have alleged was directly caused by Sarah Boone's actions or non-actions.
Again, this part, I'm like, yeah, that's basically what happened right there. Like, are you sure she wanted you breaking it down for everybody like that? It's just cringy, okay? Now, again, you know, an attorney or somebody with, you know, experience, whatnot, can break that down a little bit better, but just from the bystander viewing this, you know, and again, I almost kind of come at it like, okay, not from like a juror perspective, because obviously we follow these cases really closely, yeah, but almost in that way, like, yeah, I wouldn't want to hear the defense break that down in that way. And not that there's a juror in here right now, but you know what I'm saying? Simply because it doesn't sound good for her. I mean, when we were in the live chat, I was like, oh, he's getting fired today. I'm waiting for her to fire him. Okay, waiting for her to fire him.
What's the
Mechanism?
What is it?
They're the only ones that can answer that, Judge. That's why we asked for the statement
I don't
of particulars.
understand that circular logic. And the reason I don't is because it's your defense.
Okay. I'm assuming that they're claiming that she zipped him up in the suitcase, against his will, would not let him out of the suitcase, and therefore he suffocated. So the act of zipping him up and then the non-action of not letting him out when he asked to be let out constituted the offense of second-degree murder. That's the only explanation that we can come up with based on the report, based on the evidence we have.
Also, one thing I think, and I'm kind of answering my own question, is he's fishing. Because essentially what I gather from this is that he's almost saying, I want to know what the state's going to say so we can form the defense. I want to know what they're going to say, and I think they're going to say this. I think they'll say this right here, and it's like, yeah. And again, I don't personally know how it works, but I don't think it works that way, right? You know, so that's where when he's laying it out, I'm like, yeah, I mean, they're probably going to say that because that's what happened, right? She said this. You know, I don't know how we can get around that at this point, okay? But I just feel like it's a fishing expedition to be like, well, we'll tell you what we're going to say once we see what their hand is. And again, I don't know the legal ins and outs of that or if that's possible and whatnot, but it doesn't seem like it is by viewing the frustration that's going on in the courtroom over it.
Judge, the state doesn't know what happened the 2 minutes prior, or the minutes leading up to, the time leading up to the 2-minute video. The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that. That's for her to testify to.
This part right here, I'm like, yeah, we do. She was more than willing to tell. She was painting, they were looking at movies, they were singing, they were laughing, they were playing hide and seek. It was a good day, okay? Only Sarah Boone can testify to that. So what happened? You know, again, there's two things going here. You look at the video, so you look at what she says in the interview, right? Again, of course they want to get that thrown out. Oh, it was great, it was fine, it was this, it was that, it was wonderful, we did this, we did that. They had a whole list of activities. You thought it was field day in kindergarten, right? Then you look at the video that she recorded on her phone while she is berating him while he begs for his life. And this is for when you put your hands on me. This is for when you cheated. This is for when you call me this. So it's like, oh, this is more like retaliatory, or however you say that word, retaliation or whatever. So, and she has that very slurry speech that we've come to kind of associate with her watching these instances that she's in, that's usually alcohol fueled. She's, in my opinion, blackout state, just saying bizarre things like, and then I went outside without my shoes. If you know what I'm talking about, you know what I'm talking about. It's just this bizarre energy, okay? So let's see how it pans out.
Florida, the appellant has not cited, nor is our research located, any Florida case holding that evidence of battered spouse syndrome is admissible where the defendant claims accident rather than self-defense.
Who claims accident?
Are you claiming self-defense?
Yes.
Well, that's the first time that I've heard that.
Judge, I just mentioned it a while ago.
The word self-defense never came out of your mouth.
Judge.
Words that you believe that the state's position is, what you believe that they're going to try to establish, that we don't know what happened before and after that video. The words self-defense have never been uttered this afternoon.
Judge, for the record, we're claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense.
Okay. All right.
Not accident, as they want to allege.
Okay.
Y'all, that part, I want to crawl under the damn sofa. But it's just like, you've never said self-defense, right? It's like, oh my, but here's the thing, so not an accident. That's like a key where she's got the damn lawyer saying, if he's going to go up in there and just start outbursting, not intentional. If he in his opening statement talks about, I'm a straight A student, I'm done, okay? I'm done, okay? I excel at everything, right? She's rubbing off on him, okay? But yeah, it's like there's two things going on here. He's saying one thing and it's not translating. It's yikes, okay? Now let's look at, I think I might have like one or two more clips here, a few more things here. Let's keep going, then we're going to get into some final thoughts and whatnot.
Nobody laid hands on one another. It was a great night. We were hanging out, drinking wine, doing puzzles, painting, dancing with the dog, and then like everybody else, we were playing hide and seek, and...
Did you hear that little thing he threw in there? And then like everybody else, we were playing hide and seek. Y'all, we need to give all these, like the judge and the state and everybody, like a vacation after this is done, okay? They are so over this, right? I absolutely love that.
He got into the suitcase, and I accidentally went to sleep. And then she's shown her video. But Her statements are all that it's an accident and that there was never any claim of violence that day between the two of them. So that's wherein the state's confusion lies. And I don't know how we're going to go about this at trial, if the defendant's going to have to testify in a narrative form, if she's going to come in and testify 100% differently than how she gave statements to law enforcement.
Now again, Robert Tellis, if you haven't seen it, go watch it. I'll try and do a video one. I just haven't had time to get to it. Y'all, if she gets up there and does a narrative, which is basically like, if she does a narrative thing, she's just going to get up there and talk. We will be here for weeks, okay? They will have to get one of those, like the Gong Show, or remember the big hook they used to do on that Dylan talent show, like way back when, where they like pull you off the stage? 100% they're going to need that, right? 100%. Shut the mic off, all the things you got to do, get her off the damn stage. Take the microphone, zap her one good time, and get her off the damn stage.
Any other final positions offered in rebuttal to the state's argument, either Mr. Owens or Mr. Henderson?
Okay, I wasn't sure if I put in here, but that's the clip I was talking about where he's like, bless his heart, right? And I mean that in like the authentic way, not like the condescending. Like, there's many different versions of bless your heart. This is the real one, right? Okay. Yeah, I feel bad for the judge. Like, you can just tell where he's like, oh my gosh, please let this nightmare be over. Okay, let's get to our final clip here.
This is the defendant's trial, not Mr. Owens' trial. She has been on notice of these charges since February 25th. Of 2020. She has gone through countless attorneys here who did not pursue this battered spouse syndrome defense, even though they had consulted with Dr. Harper back in 2020. And I believe the crux of that issue is going to revolve around her having to testify in the form of a narrative given her prior statements.
Okay, so you heard him say, Dr. Harper, who we now know, that's going to be who's on the case, whatever, saw her a long time ago. The lawyer, Owen, is not the one on trial, the whole 9 yards. They've known this since February. Why haven't we heard of this? None of this, okay? So here's the thing. Right? And we're going to look at a document here in a second just to go back over it to kind of get down to the heart of it or whatever. But, I agree with the state. Obviously I'm biased. My bias is, again, from the sofa here, I think she's guilty. I think that she absolutely, they were in a toxic relationship. What I said earlier, 100% stand by that. The jury will see more evidence. Obviously I wasn't there. I don't know, right? So we'll see what the jury has to say about it. But she's had this whole time to do it. Yeah, she's probably going to do a narrative testimony. Yes, the petty part of me is kind of excited about that. Mostly, my thing is this. She has gone on for years and years and years, starting off in that interview of just wanting people to listen to her. I want someone to actually be able to sit here and say, Sarah, here's the microphone. You've had your moment. What do you have to say? You've got the world at your attention. What do you have to say? And see what she says, how she acts. Does she cry? Does she laugh? What are her body movements? The whole 9 yards. I want to see every little bit of that play out. Now, before we get to extra final thoughts, let's just look over this real quick. I'm going to put the document on the screen here. Now, you'll see here it says, again, State of Florida versus Sarah. Order on state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome and state's motion in Lamine and state's motion for examination by state expert and order on state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome. Let me catch my breath. That was just the title. Okay, so just going down to A, it says, this matter is set for trial October 7th. Going down to the next one, on September 6th, the defendant filed the certain notice of intent to rely on the defense of battered spouse syndrome. Going down to C on the next page, the notice provides statement of particulars showing the nature of the defense. Battered woman syndrome as a result of the physical and psychological abuse the defendant sustained at the hands of the alleged victim, George Torres, and the name and address of a witness, Dr. Harper. September 6th, the state filed the motion. September 13th, defendant filed the response. September 15th, defendant filed a certain amended notice of intent to rely on the battered spouse syndrome. G, the amended notice, among other things, provides the same statement of particulars showing the nature of the defense as the notice. B, battered spouse syndrome as a result of the physical and psychological abuse the defendant sustained at the hands of the alleged victim, and the names and address of 6 witnesses. September 19th, the state filed the amended motion. I, the court finds that both the notice and the amended notice comply with the Florida R Criminal P3201B. And then he goes on to cite some case law here, and he goes into that right there. We're just going to kind of go past that one here. And then K, the state relies heavily on Wagner versus state. They've mentioned this in the thing if you watch it. In Wagner, according to appellant's testimony, as she bent down to pick up the keys with her left hand, the gun that she was holding in her right hand accidentally discharged, that she absolutely did not intentionally pull the trigger, and that she was not aiming at anything when the gun went off. The bullet discharged and struck the husband in the lower back. The trial court precluded appellant from presenting the battered spouse syndrome evidence at trial. At the hearing, no outright evidence of an accident was presented. See defendant's statements as outlined. Now let's get on to the orders and it judges as follows. The motion and amend motions are granted in part and denied in part. The motion and amended motion are granted in that the defendant shall submit to an examination by an expert of the state's choosing. The list of case law. Said examination shall take place no later than September 26. The motion and amended motions are denied in that the notice and the amended notice shall not be stricken. The state's request preclude defendant from mentioning battered spouse syndrome in her opening statement is denied. State's request to prevent any mention of battered spouse syndrome until admissible evidence of a justifiable use of deadly force is admitted into evidence at trial, and admissible evidence of battered spouse syndrome is admitted into evidence at trial is denied. So this is very interesting. So, to me with this, yes, Sarah suffers a lot of losses in the courtroom, but she also gets some little wins here and there, right? And again, at this point, this is my, non-legal, whatever you want to call it. I think the evidence will speak for itself. I think they could be like, hey, you want to talk about battered spouse? Go for it, girl. Go on. The evidence will speak for itself, okay? And especially if that video of the interview is kept in there, let her get up there and talk for 3 or 4 hours. You know what I'm saying? It's very evident. I don't think she'll be able to backtrack that, and I think she might even find herself catching more charges on the stand, okay? Let's just call it what it is, right? So, yeah, overall, I thought this was very interesting. It was also like a precursor to see how this could potentially go down in the courtroom. Hopefully, her defense will get a little bit more prepared, and they are working around the clock to be able to come at them with stuff. Basic things, writing dates on papers, having the case law that he needs, whatnot, right? Again, I understand he's coming at the last moment, and he's brought all these other people in. Now, in this, he had other lawyers talking. It was crazy, noises on the computer and all this type stuff. It was very, so, yeah. So that's it. Thank you for hanging out this whole time and listening to this. I'll put a link down below to the live chat if you want to watch that version of it too. But that's it. I do appreciate it. Let me know what your thoughts are down below. And if you could drop some little sofas off for myself, Rosco and Spirit, and the 2 little boys, Bo William and Luke Connor. I should say those are their official names. They are out playing, being babysat right now actually in the other room. So they'll pop their heads up for the next video. But that's it. I do appreciate y'all watching until we meander down that comment section to hang out on the sofa and play and talk and comment and all that kind of stuff and play hide and seek. We'll see y'all soon. I just wanted to say thank you again for watching the whole video, and also thank you for being part of the Sofa Squad. Special thanks to all the Patreon members, channel members from both of my channels, everybody who likes, shares, subscribes, comments in the comment sections. It helps the channel out so much. Now, don't forget, I do have that other channel, the podcast channel. That's where we go live, we hang out, we talk. We have kind of sort of a schedule, but just be sure and check it out. I'll put it up here on the screen. Also, if you're looking for merch, be sure to check out my Teespring store. I'll put that up here. And then, like I said in the beginning of the video, if you want to follow me and Rosco on the Instagram, go on, check it out. It's right here on the screen again. But once again, thank you very much. I really appreciate you being part of the Sofa Squad, and I'll see you in the next video.